One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, "Oh, I'm just going to JV it." Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, "Well, I didn't fully understand that it was subject to."
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. I am Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like. You can find us on Facebook. You can find us on Twitter, now known as X, and you can find us on YouTube. On YouTube, we are at InRem Podcast. That is at InRem Podcast. So go to our YouTube channel. If you haven't been to it, click the like button, click the subscribe button. We'd really appreciate that. In addition, we are also available as an audio podcast on both Spotify and Apple Podcasts. So make sure to give those a download, a quick, super easy and cheap, free way to listen to the podcast without having to be in front of a screen. With that, we're going to get into a couple announcements before we get started in our show. So a reminder, tomorrow is the Creative Finance Collective. We do that weekly, every Wednesday at 5 o'clock p.m. So what is the Creative Finance Collective? Well, one, the term creative finance indicates we are talking about all things creative finance related. So if it has to do with creative finance, or even tangentially related to creative finance, it is open for discussion. We've got our targets set on it. We want to talk about it. We don't really have an agenda going into this, but this is attended by professionals within the creative finance space that approach it from a variety of different states and jurisdictions. That gives us as attorneys the ability to bounce around ideas, see what other folks are doing, but it gives you, the listener, the ability to watch and be a part of the discussion by asking questions. We open for the entire hour. We make ourselves available to you, the listener, to ask any questions that you have. There is no dumb question. And the more questions you have, usually the better the discussion is. So make sure you're there as part of that. Again, live Arizona time, 5 p.m. Sean, I don't think most people realize how valuable the Creative Finance Collective is. And maybe that's because not enough of them have had to go pay for a lawyer for a consultation.
Well, and that's just it. I'm hit up quite a bit, whether through social media, phone calls, emails saying, "Hey, Sean, I'm dealing with this, creative finance issue. I'm dealing with this real estate issue. I'm dealing with this. You have a quick moment to talk," and my response is, well, we can do this one of two ways. One is you can set a formal consultation with me, and it's a paid consultation, and put a time on my calendar. Or alternatively, I make myself available, whether through the InRem Podcast or the Creative Finance Collective, where you can ask law-related questions. And, we're not going to give specific legal advice, but we'll give some basic information. Maybe we'll have a referral to an attorney that can provide assistance in the state or that they're dealing with. But you can at least get some legal guidance and legal information in response to your inquiry or your question. But you have to show up and participate. That's when I'm available. It doesn't cost anything. You just simply have to tune in at the set time and present your question, present your scenario, and we'll do our best to give you some legal guidance, free of charge. And so it is invaluable. I don't think people truly appreciate that. But that tends to be my response. So if you want an opportunity to connect with attorneys that are very experienced with real estate, with creative finance, with any type of real estate investment activity, that's your opportunity. And it's just not me that's on there. It's not just you, Andy. I mean, we, in my view, have some of the most experienced attorneys in the creative finance space on this show regularly. And so it's just an incredible opportunity for somebody to tune in if they're dealing with a situation, to, in general terms, put it out there, and we'll see what we can do to, provide some guidance.
Yeah, there's only a handful of people in this space. And when I say in the space, like really in the space, that know it in and out. And it's not just theoretical to them. They're doing it all the time. And to have that collective wisdom available to you throughout the course of an hour for free that's just something you got to take advantage of. So again, tomorrow, 5:00 p.m., we're taking questions. Make sure to be there. There are no dumb questions. Ask them. We'll do our best to answer those. All right. We are also taking questions throughout the show today. We usually take questions in the final 15 minutes. I'm going to turn it over to Mayu, who can give you instructions on how to go ahead and post your questions.
Thank you, Andy. Good morning, everyone. You know what time it is. That's right. We are up early for the InRem podcast. As always, Andy and Sean and our guests are here to answer your questions live on the show. If you're watching us live, whether it's from the InRem YouTube or Facebook pages, and you have a great question in mind, be sure to leave it in the comments. We only take about 10 to 15 minutes at the end of the show, so don't wait. If you have a great question, drop it in the comments below, and we'll try to get to all of them at the end of the podcast. So let's not wait any further today. I will turn it over back to you, Andy.
All right. With that, we're going to get into some of our topic today, and we're going to start with Sean, who has our legal update. And just for reference, we've had some problems connecting with our guest and getting them on the show. So we may bring them forward if they're able to get on, but if not, we're going to have a continued discussion on Sean's legal update. So Sean, I'm going to turn it over to you for the legal update.
Yeah. So my legal update today is another what if scenario. And the what if question of the day is, what if a seller, I'm looking at the wrong outline. What if a lender invokes the due on sale clause following a subject to purchase of the property? So the buyer has acquired the property subject to the existing loan. The lender determines that falls within the due on sale clause and gives them the right to invoke the due on sale clause and accelerate the debt. What happens? So universally, it's not required as part of the language, but in every due on sale clause that I've ever reviewed, whether that's through a private lender, whether that's through conventional Fannie Mae, Freddie Mac, FHA, VA, every due on sale clause that I have reviewed has a provision in it that states that if the lender is going to exercise its right under the due on sale clause, it will send a notice to the borrower stating that they have 30 days to pay the full balance of the loan because the property has been transferred to a third party. So that's a pretty standard provision and something that the lender has to do. So they basically provide what we call a notice of acceleration in the legal realm, but it's basically a notice saying, hey, you've sold the property, you've conveyed the property in violation of the due on sale clause. We now have a right to require that you pay the loan in full. Now, within that 30-day period, the lender generally includes in their notice of accelerating the debt. Now, they don't have to do this. If you look at the express language of the due on sale clause, it generally is not something that the lender has to do. They basically could fully accelerate and say, you have no option. You have to pay us in 30 days. But that's not normally not what the lender does. Normally, their letter that goes out states that, hey, look, you've transferred the property. You have 30 days to pay the loan balance, or alternatively, you have 30 days to put the property back into your name and to come back on title to the property. So what does that mean? Well, in that case, you can, as the investor or the purchaser, if the seller's willing to cooperate, you can work with the seller to restructure the transaction so that title is put back into the seller's name. And the way you do that is you execute a warranty deed from the buyer to the seller, which conveys title to the property and puts it back into the seller's name. In conjunction with that, you work with the seller to restructure the transaction. And there's a few ways to do that. One is you can restructure it using an agreement for sale, which is, and we've talked about this over and over on the show. It's basically, some states call it a contract for deed or a land installment contract, but it is a document that, or a contract that basically states that I, as the buyer, have an equitable interest in the property, which includes full possessory rights to the property, and I can use the property as my own. However, I don't have fee simple title. The warranty deed remains and title remains in the name of the seller, and I have to make payments to the seller pursuant to the terms of the agreement for sale. Generally, if it's a subject to, you would be making payments identical to the existing loan. I'm going to make payments according to our agreement. And then when I fully pay and perform, then the warranty deed is transferred back into my name. So you can do an agreement for sale. Now, the agreement for sale is generally, and I recommend that it is recorded with the county recorder's office where the property is located. And most due on sale clauses, not all of them, but most due on sale clauses are going to say, well, that would also be a violation. But you put the property back in the name of the seller, and then you go forward with the agreement for sale. And then the lender has to decide at that point whether or not to, say, well, we don't like the agreement for sale. In my experience, lenders are less concerned about an agreement for sale than a straight warranty deed transfer, because the seller still maintains fee title, ownership of the property. They just don't have full equitable ownership or possessory rights to the property. So, the lender may be like, okay, we're good. Title went back into the name of the seller. We're not going to invoke, further invoke the due on sale clause. So that's one option. The second is to execute or put in place a lease for the property, a long-term lease with an option to purchase. Now, a couple of things. Many due on sale clauses don't prohibit long-term leases of the property. Some of them do. Some of them say, well, if you lease the property for more than 3 years, that would be a violation of the due on sale clause. Federal law basically says that a borrower can lease the property up to 3 years without there ever being a due on sale clause issue. So you have up to 3 years, or if the due on sale clause doesn't specify, then you could lease it for 5 years or 10 years, and it wouldn't be a violation of the due on sale clause. You would have to look at the language. But in any event, you can enter into a lease that either complies with the St. Germain Act, which is federal law, by making it no more than 3 years, or you enter into a lease for a longer period if the due on sale clause doesn't prohibit it, with an option to purchase the property. And then if you structure it that way, you don't have a due on sale clause issue. You would have the ability to, have that option to purchase along with that lease in place. And lenders are not going to take issue with that, even though potentially, and it's kind of gray, whether the option to purchase would, create a trigger for the due on sale clause. Generally it doesn't. And generally lenders, aren't, even if it does, aren't going to care about an option to purchase. So those are the ways that you would restructure. So basically, you would, if you're going to restructure, you would pay off, or you would convey the property back into the name of the seller, do an agreement for sale, or convey the property back in the name of the seller and do a lease with an option to purchase. Now that's one option. Now let's say the lender invokes the due on sale clause and you're like, I don't want to restructure. Well, you have the right within that 30-day period to go, as the owner of the property, as the buyer, to go and sell the property to a third party and pay off the loan. So you can do a, traditional sale of the property. You can sell the property, you pay off the existing loan, and you're free and clear, and there's no issue there. So that's your second option. The third option is to refinance. You could find a lender. Now, it kind of may not be the best scenario because of the interest rates that we're dealing with now, but assuming you could find financing with an interest rate that you can live with, you go and you refinance, you obtain financing in an amount necessary to pay off the existing loan. You pay off the existing loan and you own the property, continue to own the property free and clear, and you have no issues there. So basically, if a lender invokes the due on sale clause, you have three options. One is to restructure to satisfy the lender's requirements. Second, you sell the property to a third party and pay off the existing loan in the process. Or three, you refinance and pay off the existing loan in the process.
All right, Sean, thank you for the legal update. So with that, we're going to expand our discussion today into really a broader discussion of creative financing and the due on sale clause, and talk in a little bit more detail about it, whether you should care, why you should care, whether it's as scary as it sounds, so on and so forth. So, Sean, the due on sale clause is obviously the boogeyman in creative finance transactions. And by that, I mean, on one hand, it's the most frightening potential piece of the creative finance deal, but it's also the most rarely seen, compared to maybe even if we were to talk about all the liabilities that might attach in creative finance, you could make a good argument that your failure to disclose a lot of what you're doing creates much more liability than what you would ever have to worry about with a due on sale clause. But it's out there, and it's something that needs to be addressed. And it's rarely seen, I think, but it's something we've actually seen in pretty recent history, right?
Mm-hmm. Yeah, it happens. And lenders do invoke the due on sale clause. And it really depends, in my view, who your lender is as far as the chance or the likelihood that the due on sale clause is going to be invoked. So if the lender that makes the loan also services or holds the loan and they don't, securitize it or wholesale it, so that it becomes part of a larger fund, it basically becomes part of a stock portfolio or mutual fund with many different owners that hold it basically in trust. That's what securitization is, right? You basically pool and package loans and you put them out in the market, and people can actually buy very small interests in those. And you have, I'm sure you and I, in our retirement accounts, we hold some small percentage of a loan portfolio as part of our investment strategy, because most, mutual funds include that type of investment. And so
Sure.
They basically are there and they're packaged, they're securitized, they're bought and sold in the open market. And you have some trust that, basically holds it for the benefit of its, hundreds of thousands of investors that are out there that hold a very minute, percentage of the loan. Well, that trust isn't going to be the one that services the loan. You have a separate company that services it. What we mean by servicing it is they don't have an ownership interest in the loan. They have the right to collect payments, and then they get paid a very, very small percentage of every payment that they collect. And then they pass the rest on to the actual holder or the trust that's holding the loan for the benefit of all these investors. Now think about that. If a servicer is getting paid and they're putting even a small percentage of that in their pocket, do they really care who's making the payment? Do they care that the loan is, it's been sold? They don't own the loan. They don't bear the risk of the loss. All they want to know is, hey, I'm getting paid. I'm passing the money on to this, investment trust. They're happy. They're getting their money. We're all happy. Nobody cares, right? Now, who cares is Fannie Mae, Freddie Mac, who, is insuring these loans. And, they're federally insured. And so it'd really be incumbent upon Fannie Mae, Freddie Mac, or the insurance company to basically do random audits to figure out, whether or not the property's been sold and whether or not it makes sense to, move forward with accelerating the debt. Does it happen? It can happen. I'm not aware of it happening on a regular basis. It's less than a 5% chance from, in my experience and my research is less than a 5% chance that the lender is actually going to call it. So if you're dealing with what we call a conventional loan insured by Fannie Mae, Freddie Mac, it's a very small likelihood that, the servicer is going to see, hey, the payment's coming from somebody else, or the insurance is listing somebody else as the insured. We're going to now go and call the loan due when in reality, we're getting our payment every month. We're getting paid. We're making the holder happy by passing the payment on to them. Nobody, is going to, in my view, be concerned about it. I mean, they're all looking out for their self-interest, right? And their self-interest is just keep the loan good. I mean, we're getting paid, right?
Right. Yeah.
And so that's number one. The other type of loan is your smaller community bank loan, your loan where it was funded and held in service. So we call those portfolio loans. They're not securitized. They're not bought and sold out there on the open market. They're portfolio loans, and those lenders are going to be a little bit more on top of it. And that's the most recent case that I'm working on where the lender did call the loan due is the lender funded it, but also maintained it as part of their portfolio. Even though it was a large lender that you would have thought would have securitized it, they didn't. They held it as part of their portfolio. They did, a random audit, found that the property had been transferred, and then said, hey, look, either put the title back in the seller or, we're going to accelerate. So, we did kind of some restructuring on that. But in any event, if it's a portfolio loan, yeah, they have a much smaller pool of loans that they're handling. They're going to be looking and doing, their random audits. They may have people who receive the payment and look and say, well, why is this coming from so-and-so and not the borrower? Why is the insurance showing so-and-so as the insured? So, your percentage of the due on sale clause goes up a little bit when you're dealing with those types of loans. I don't know how much, of a greater percentage that is, but it's a greater percentage for those types of portfolio loans. FHA loans, you have a little bit more risk too, because the FHA does not want or like their loans wrapped. And so if you're going to do a wrap, FHA doesn't like that. And they, take steps to try to, discourage that, to prevent it. And one of which would be, calling the loan due. So, that's something to consider too on an FHA. VA, they're serviced and held the same as a conventional loan. The only difference is that the VA insures it. And so the VA, similar to the FHA, will maybe do a little bit more auditing than you might see with, a Fannie Mae, Freddie Mac loan. But nevertheless, VA is similar to FHA, and then they don't, it says it right there on their deed of trust, like, hey, don't convey the property or try to have someone else assume the loan without getting our, written permission. And it says it there. So they're, they give that warning. They clearly intend to enforce the due on sale clause, and it's obvious by their documents. So you may have, a little bit more risk with a VA. It's not illegal to wrap a VA loan or an FHA loan. It just basically puts you within the due on sale clause provisions, which means that the lender has a right to accelerate if they so choose. on that loan.
Well, I want to explore that a little bit, because there is still this idea, and there's still a sentiment. This even happens among lawyers, mainly the litigating attorneys who are looking for an argument to litigate over things. But there is still some sentiment that creative financing is in some way illegal. So when we hear terms like calling the loan due, or we hear terms like FHA doesn't like this, they don't like their loans wrapped, or this lender might be more inclined to call the loan due in this circumstance, there is this sentiment that, oh, this must mean that it's wrong or illegal. Now, we've devoted entire shows to this, but why don't you kind of address really the difference of what is illegal versus what is actually going on in creative financing?
Yeah, so let's first look at Arizona, which followed California in this case authority. But starting with Arizona, back in the late 70s, early 80s, we had a whole line of cases, including a seminal case from our Arizona Supreme Court, which basically said, hey, look, lender, we as a state are not going to allow you, lender, to enforce the due on sale clause as written, because we think that would be a unlawful restraint on alienation, meaning, a borrower,
Your ability
owner,
to transfer.
can't transfer the property, and it's illegally restraining that. And, part of the country is the ability to transact with property. I mean, that was a major
Yeah,
thing when
that
country
principle is
became
part and parcel to real estate law from its inception, right?
right. Yeah, from the Declaration of Independence to the Constitution and forward. I mean, free ownership and ability to own and convey and transact with respect to your property has been protected for forever. And so, as a state, and our Supreme Court said, hey, look, this is how Arizona is going to approach it. You cannot invoke the due on sale clause as written. So if the due on sale clause says that the minute the property is conveyed, the lender has the right to accelerate and you owe everything. No. Instead, in order for the lender to enforce the due on sale clause, the burden is on the lender to show that the transfer jeopardized the lender's security interest in the property. So basically, the lender has to come forward and say, okay, I'm no longer in first position, if that's the position that they were going to be in. I'm no longer in first position on the property. Or they can argue and present like, hey, this buyer, whoever bought this property is not in as good of financial shape, is not as well qualified as the original buyer or borrower on the property. So, doesn't have as many assets. So the lender has to prove all that. The burden is on the lender to prove that their security is jeopardized. So they can't just come in and say, oh, property's transferred, we want all of our money. No. You have to actually go in and say, look, court, here's why that transfer is not enforceable. Here's why, the borrower, the owner could not have transferred the property because it's going to jeopardize our security interests in the property. That's a big burden and something that must be shown, especially if the property is in default, the borrower wasn't making payments, and you have a buyer who comes in with assets and resources, brings the loan current, and then takes over the loan and makes the payments for 6 months. I mean, how are you going to establish that then, that all of a sudden your security is being jeopardized? If anything, you're in much better shape because you have a buyer that stepped in, that said and committed to the seller to make the loan payments. And oh, by the way, they're making those loan payments. A seller who was, in distress. So, it would be a hard burden to prove. Now, I say all that, and I wish that were still what we had here in Arizona or, in California, across the nation. But it's not. And the reason why it's not is because as California and Arizona and some other states were coming out with these, cases and these decisions, the savings and loans, the credit unions, the banks, they did not like that.
The feds always ruin the party.
They do. And so the feds ruined it. They lobbied the feds and said, hey, look, feds, like, you're insuring these loans and, we're losing money. You're losing money. This is a bad line of authority, case authority. We need you to, put a halt to it. So they did. The Garn St. Germain Act passed in, I want to say 1982, effective, I think 1983. So Garn St. Germain comes out. And Garn St. Germain basically says, hey, look, for any federally insured loan on residential real estate, so that's important, residential real estate, we are not going to allow you states to dictate how the due on sale clause is going to be enforced. Instead, you will enforce the due on sale clauses as written. And that's their requirement. Now, what's interesting, though, is the Garn St. Germain Act did not come full on with no exceptions. It created 9 different exceptions to the due on sale clause. So even if the due on sale clause says, hey, borrower, you can never transfer the property ever. Under no circumstances can you transfer the property. And if you do, you have to pay us in full. Garn St. Germain said, yeah, that's good and all, but not in every case. So it laid out 9 exceptions, one of which is if the original borrower dies and the property is conveyed to their heirs can keep the loan in place and make the loan payments, and the lender can do nothing about it. If the original borrower goes through a divorce and the property is awarded to the spouse, title can be conveyed to the spouse, even though the spouse wasn't the borrower, and there's nothing the lender can do about it. If the owner wants to convey it to a trust in which they're the grantors or settlers, basically the creators of the trust and the trustees and the beneficiaries, you can transfer it to a trust for estate planning purposes, and there's nothing the lender can do about it. And I can go on, but it's those types of transfers. It is not a subject to conveyance to a third party. Let's get that straight. There is no exception in the Garn St. Germain Act for that, unfortunately. But nevertheless, you have all these exceptions. And so for someone to come forward, in my view, and say, okay, well, look, if you alienate the property in violation of the due on sale clause, oh, that's illegal. Well, what if somebody dies and it goes to their heir? That's a violation of the due on sale clause. Perfectly fine. And federal law says it's okay, right? So in reality, what you have is you don't have an illegal act, because otherwise, we wouldn't have exceptions to the rule. We wouldn't have court cases, saying that the due on sale clause doesn't apply. And what's interesting is the court cases here in Arizona also, even though they're preempted as to residential real estate, they're not preempted as to commercial. So subject to transactions on commercial, even though you've conveyed the property in violation of the due on sale clause, doesn't mean that the lender just gets to run into court and say, oh, there's a violation here, due on sale. No, in Arizona, they're going to have to show that their security is being jeopardized as a result of the transfer on commercial property. So once again, that further shows that it's not an illegal, act.
Well, and I think a lot of times people conflate the term illegal with civil liability or civil kind of risk exposure that you might afford yourself to if you take a certain action. Illegal in the strictest sense means they're going to fine you and put you in jail or something to that effect. You've broken some laws in that regard. We're not saying, and I know you'll probably expand on this, we're not saying that there's not any risk associated with offending the due on sale clause, which you almost certainly will do in a creative finance transaction. We're not saying that there's not some risk associated with it, but to ignore that the conversation ought to really just be about whether this is risk I'm willing to take versus, oh, this is illegal and you can never do it, is really a dishonest conversation.
Well, that's exactly right. And we also see these statements coming from real estate agents and brokers, who, there's sometimes this conflict between investors and real estate agents and brokers because there's a lot of off-market activity that happens, which of course, means that they're not hiring real estate agents or brokers to represent them in the transaction. And so you have these real estate agents and brokers who are like, oh no, this is illegal. You can't do that. We're not going to be party to this. We're not going to represent a party in a subject to transaction. What's interesting is it's the same real estate agents and brokers who were assisting their clients with short sales back in 2008 through 13. Well, what happened in 2008 through 13? You had a bunch of people who stopped paying their loans, which is a breach of their loan documents, breach of the promissory note, breach of the deed of trust. And they weren't running around saying, well, that's an illegal act. No, they were saying, oh, if you can't pay your mortgage, well, then, we can do a short sale or a foreclosure or something like that. And you had all of these people who were breaching their loans, violating the terms of their loans, and they weren't going to jail. Instead, these same agents and brokers that are saying that the subject to transaction is illegal was representing them and to do a short sale, right? It's really, in my view, no different. There's a provision in your documents that states what happens if you engage in certain conduct. So there's provisions that say what happens if you don't pay your loan. Well, the lender can foreclose. And then there's a provision that says what happened if you sell the property. Well, your lender can accelerate the debt and call the loan due. It's all of it is a breach, or maybe not even a breach, but it's a contractual provision that says if you, as the borrower, engage in certain conduct, you give additional rights to the lender, and the lender can choose to enforce those rights. That's basically what happens. And so we have this concept that we learned in law school in contracts class, our, contracts 101 or 1 or whatever the name of the course was. My very first contracts class in law school, I remember the professor talking about this idea of efficient breach, that there are going to be times in the real world where you as an attorney are going to come across a situation where it is better for your client to breach the contract and face the consequences than to adhere to it. And that's okay. That's not illegal. That's not criminal. That's not, going to put your client behind bars. It simply gives the other party to the contract certain civil rights and remedies that they otherwise wouldn't have. And there have been state bars. Unfortunately, I'm not aware of an opinion in Arizona, but there's an opinion out of Virginia and a state bar opinion out of Illinois where this very topic of can an attorney represent a client and advise them on whether or not they can sell their property subject to a due on sale clause. And both of those opinions clearly stated that that is acceptable for the attorney to be involved. The attorney has the ability to advise their client as to what it means to adhere to the contract, what it means to breach the contract. And then if the client decides to, move forward with the breach that would give the lender additional rights and remedies, they can prepare the documents for that. In fact, Illinois talked about efficient breach when they came out with their decision. And they basically said, sometimes you may have a client whose economic survival is dependent upon their breach of the contract. And so Illinois said, you as attorneys, that's your job, is to advise your clients of what it looks like to go in both directions. And then if your client decides that they want, to legally move in the direction of, selling the property, you can then prepare the documents to sell the property as long as the client fully is informed and understands the consequences of doing so. So once again, we wouldn't have state bar opinions out there saying, look, attorneys, you can assist your clients in this transaction if it was going to be illegal. I mean, our ethical rules say that us as attorneys can't engage in illegal acts or assist our clients in engaging in illegal acts. And so selling the property subject to a due on sale clause is not an illegal act, but it does give the lender additional rights and remedies that they otherwise wouldn't have. And all parties to the transaction need to be aware of that and know the potential consequences of that.
So let's talk about those potential consequences.
Yeah.
The due on sale clause, like we mentioned, is out there. Even if it's a rare occurrence for a lender to call it due, it doesn't have to be. They can call that loan due potentially at any time, assuming you violated the due on sale clause. What I want to do is talk about, there are ways to inadvertently notify a lender of certain things, and there are ways to kind of expose yourself inadvertently that one ought to avoid. And some of those happen within, or can happen within, the creative finance transaction itself, if you're not careful. Now, one interesting way, we've talked about this on the collective a couple times. I haven't run into this personally, but now have spoken with a number of attorneys who have run into this on a few occasions, which is sellers deciding to just blow up the deal later on after the fact because of whatever reason. It's Tuesday and it's snowing and they're just mad. Who knows? But they decide to just call the lender. I mean, so that's certainly a possibility. That could happen. That's outside of your control. I don't know that there's a lot that you can do to mitigate against that, except for making sure you heavily disclose everything about what you're doing on the front end to reduce the likelihood of a seller being upset after the fact. Beyond that, have you thought of any other ways that you could even stop that? I really haven't.
Well, so in Arizona, we have implied in every contract a duty of good faith and fair dealing. And the duty of good faith and fair dealing states that no party to the contract will engage in conduct, even if not expressly prohibited by the contract, but they will not engage in conduct that would deprive the other party of the benefits of that agreement. So in Arizona, if you have a subject to transaction and it's been fully disclosed and the seller fully appreciates the nature of it, and they just have seller's remorse at some point in time and they become mad and it's a bad day for them, and they decide, you know what, I just want to be done. I'm going to call the lender. I'm going to, get them to accelerate and I'll show this buyer, right? They do that. Well, by law, that is a breach of the duty of good faith and fair dealing, and the seller is liable to the buyer for that. So what I do is, in my creative finance contract, or I think it's actually in my subject to addendum, I put in there a provision that says that the seller's not going to engage in any conduct which would deprive the buyer of, their ownership of the property, their rights under the contract, or even result or cause the seller to, invoke the due on sale clause. I've actually had that issue questioned before by a litigator, of course. And the response was just what I said, which is, well, why is that a bad provision when simply all I'm doing in the contract is restating the duty of good faith and fair dealing that's implied by law? I'm not, trying to put anything in there saying, oh, we're going to, do this secretive deal or whatever. I'm just simply saying, seller, once this thing is consummated, you're not going to do anything that's going to deprive the buyer of its rights under the contract. The contract that's been fully disclosed, and exactly what's going on with the transaction. So I don't believe Arizona is the only state that has this duty of good faith and fair dealing. I don't know that it's, in all 50 states, but I know that there's other states that have this same thing. And I don't think that there's an issue with putting a provision to that effect in the purchase contract, and is any way trying to, create some type of concealment or otherwise with the lender. It's just simply saying, hey, seller, you're not going to actively try to destroy the benefits that the buyer has under the contract, which is implied by law anyway in the contract. I'm
What
just
about
having it expressly stated in there.
what about having them indemnify you from any damages that occur as a result of that's taking it a step further, right? That's more than what the law would just generally apply with good faith and fair dealing and adds a remedy to you in the event that they do that.
Yeah, but I think you still have a remedy and your damages are the same,
That's
which
true.
is, what is your loss? And either way, you're still going to have to file a lawsuit against the seller. You're still going to have to, pursue damages. And to your point, I think it's a fine provision. I don't think it's wrong. I don't think it's improper to put it in there. But you are taking it further than just simply restating the duty of good faith and fair dealing.
Yeah.
Now, one interesting thing is, and I kind of, anytime you start talking about liquidated damages, it can kind of work both ways. But one provision you could put in there is that if they do engage in conduct and the lender does, as a result of that conduct, call the loan due, you could potentially put a liquidated damage provision saying, look, I don't know what this damage is going to be other than I'm going to lose the property. And therefore you agree to pay damages of, X amount of dollars if you engage in this conduct. That may be enough, of a deterrent to convince the seller not to engage in that conduct. Now, you and I both know liquidated damages are provisions that tend to be fairly difficult to enforce. There's additional hurdles that you have to go through to enforce a liquidated damage provision than just putting in the magic language in a contract. I mean, there's additional things you have to prove in litigation in order to recover those damages.
So what are ways in the creative finance transaction, ways that if a buyer is not careful in structuring or either of the parties is not careful in structuring the transaction, that they can inadvertently send notice or provide notice to the lender of what's going on and have them trigger the due on sale clause? I know this can happen. Seems like it can happen most often in the insurance context, but what are your thoughts?
Yeah. I mean, if the seller doesn't fully appreciate the nature of the transaction, I've heard stories of the seller, calling up the lender in advance and being like, hey, I'm selling it to so-and-so. Are you going to sign off on it? And they're like, no. And then of course they put a little, reminder, hey, check this property in a month. Let's see what happened. Right. Okay. Or, I've heard stories of the title company sending, payoff requests or sending the final settlement statement to the lender, with the reinstatement check and, those types of things. And I'm not saying to hide anything from the lender, but there are certain things by law that you have to disclose and certain things that you don't have to disclose. And only the parties to a transaction, the buyer and seller, are entitled to the final, HUD-1 settlement statement. And so the escrow agent has to obtain both the buyer and seller approval to disclose that settlement statement out to any third party, including a lender. So, that's another example. Insurance is a big one. Now, we've had Mike Munzingo on our show before. He's out of Texas, very experienced with subject to and creative finance transactions. And, he's an investor himself. And he, on our show, explained like, hey, look, the way I structure it, I put the buyer as the insured, the seller is additional interest, and the lender is the loss payee. And I submit that to the lender and I don't have a problem. And my, insureds don't have a problem. The buyer doesn't have a problem. And the seller cancels their original policy. And then the new policy is paid as part of the mortgage payment. I don't have a problem with that. But I also have some clients who say, Sean, I don't want to risk it. I'm going to just go out and get my own policy of insurance. I'm going to keep the sellers in place. I'm not, and listing me as the insured. That way I'm covered if something happens, but I'll pay double for the insurance. Okay. But I don't think insurance is really what causes these loans to be called. I think it's really just random audits or something that's said in the process by the seller, either before or after the transaction. That's generally what happens, because in reality, on the insurance side of things, once again, it's getting to this idea of this servicer, and they have multiple departments. And we learned this from the short sale days, that they have, kind of their little script and area that they work in, and they're not allowed to really venture out of that.
They're sticking to that script.
Yes. And so their script is, we need insurance. And as long as we have insurance for this property in the right amount, we put our check mark by that property and say it's good, and we move on to our next transaction. It's not our job. We're not paid to, we're not required to, and it's outside of our box to try to figure out if the property's been sold. All we're doing is figuring out, is there insurance? And that is, I believe, to be the case. Now, lenders may at some point in time say, oh, no, we're going to train our insurance people to spot, these issues and let us know and whatnot. We'll see if that ever happens. But,
yeah, good luck.
As it stands now, I don't think insurance is really something that triggers it, especially if you use an experienced insurance agent that knows how to deal with these transactions and submit the document and structure it the right way and then submit it the right way.
We have a few questions. Mayu, why don't you give those to us?
Yes. All right. So we do have a couple questions today. Thank you everyone for asking them. I'm going to, I'll read the first one to you guys, and it's up to interpretation. So the first question was, is it safe to do a lease option to start with instead of subto?
Sure. In fact, now, once again, I said there's a gray area on whether or not a option would invoke the due on sale clause, but in reality, the due on sale clause, the conventional one, Fannie Mae, Freddie Mac due on sale, at the very end, it says, even an escrow agreement through which the borrower intends to convey title of the property at a future date is a violation of the due on sale clause. Well, that would even be a purchase contract. However, an option to purchase as opposed to a right to purchase are two different things. And an option doesn't mean that the borrower intends to. They would only convey it if the optionee steps up to the plate and purchases it. So look at the language of the due on sale clause, but generally lenders are not going to take issues with leases. Leases are not a recorded document. So they, a lender likely searching the public records wouldn't even know that it's out there. And then all you would see or find is an option to purchase, probably is not going to be a violation of the due on sale clause. And the option to purchase should not, or the memorandum of the option to purchase should not reference the lease. There would be no purpose in referencing the lease other than just to say, hey, I have the right to purchase at some future time. So yes, you could do a lease with an option to purchase, and you likely would not fall within the provisions of a due on sale clause. Not guaranteed. Look at the language, but and consult with an attorney in the state where you plan to do the lease with option to purchase. However, there are some downsides with leases with options to purchase. So the first is the ability to claim the mortgage interest deduction to depreciate the property. And then third, and we covered this with Bill Bronchick, which is if the seller or landlord in this case files for bankruptcy, the trustee can set aside both the lease with and the option to purchase, and you're out. You don't have any rights to the property. So keep that in mind as well.
Yeah, and it's worth reminding everyone that when we say check the language of the due on sale clause, there is not a universal due on sale clause that means the same thing to everybody in every transactions. We've even talked about this, in the past. We've done entire shows on it, but every lender can use a different one. There's some that are typical that you might see with FHA or the VA, but everyone can be different. So
Correct.
read it. Mayu, what other questions do we have?
Yes, we have one more question. This is a scenario, so let me read here.
Hypothetical.
I have a home I own on seller financing. I leased it for 3 years to my father. I also had a lease option agreement in place for his purchase. In the matter of probate, is his lease option purchase considered a priority and debts to be paid? An additional note was that my father passed away about 4 months into the lease.
All right, keep that question up there because I'm going to have to. I have a home. I leased it for 3 years to my father. So correct me if I'm wrong, Andy, on this, but I think the way this would work is the lease. You have to look at the language of the lease, but generally leases terminate upon the death of the tenant. So if the tenant dies, you generally cannot hold their estate liable for the ongoing rent under the lease. Instead, they're only liable for any unpaid rent from the, during the term of the lease until basically they vacated the property or their, stuff has been moved out of the property. And so any rent up to that point would be due and owing and would be not a priority debt, just a standard debt of the estate. At least here in Arizona, it would be a standard debt of the estate. However, the option, depending on the language and whether it's binding upon the heirs, successors, and assigns, the option would be an asset of the estate, and the estate could could convey or assign that option to the beneficiaries, who at some point could then choose to enforce the option. I think
that's right.
Yeah. Speak with a probate attorney in the state where the property is located to get specific advice on that. But my recollection in the work that I did do in probate over the years is that that's how it would play out. So yeah, but definitely consult with an attorney and get some specific legal advice in the state where the property is located, a probate attorney, to make sure that that's how it would play out in your state.
All right. Well, good stuff. Thanks everybody for joining us. That is our show, an hour on the due on sale clause. Hope it was informative to you. Make sure to join us next week. Also, make sure to join us tomorrow again at 5 p.m. for the Creative Finance Collective. We'll see you all next time.
Have a good day, everyone.